Nothing says untouchable like being a high-profile union leader in America. From dictating COVID-19 policy to damaging property during strikes, unions are notorious for playing by their own rules, at least until now. As of today, the Supreme Court is hearing arguments in Glacier Northwest Inc. versus International Brotherhood of Teamsters, a case in which union bosses are trying to maintain a special legal privilege that protects them from facilitating property damage in a labor strike. The incident in question happened in August 2017 when a group of truck drivers from the International Brotherhood of Teamsters walked off the job, leaving wet concrete to harden in the trucks. And Glacier Northwest, the Seattle-based company who makes the concrete, is reviving an old lawsuit against the union for damages. Originally filed in 2021, justices at the Washington Supreme Court tossed the case, saying that the concrete loss happened during a legally protected strike. The building supply company, which lost $100,000 because they couldn't honor a contract as a result of the strike, is now hoping to receive some compensation. The Supreme Court will likely rule in favor of Glacier Northwest, lest the National Labor Relations Board decides to conduct its own investigation. Current deliberation will decide whether this lost product constitutes collateral damage, which is not the fault of the workers, or intentional property destruction, which leaves the laborers liable. A classic dilemma, the case puts Biden and his union buddies in a bind. Will he side with the mob dons in his pocket or with the middle-class building supplies company? The middle class built this country, but the labor unions built Biden's career, bringing us to an interesting dilemma. In any event, this case represents a long battle between business owners and labor unions. And given the list of legal protections that unions get, who could blame business leaders? But a recently achieved conservative majority means that labor unions can't always rely on activist judges to do their dirty work anymore. You may recall that in 2018, the court said that non-union public sector employees cannot be forced to pay for the cost of negotiating contracts. Therefore, a tip in the scales could be the end of special treatment for unions. Joining us now to discuss is Mark Mix, the president of the National Right to Work Legal Defense Foundation. Thanks for being here tonight, Mark.
Kara, good to be with you and talk a little bit about the special privileges, to your point, that union officials enjoy under the law. And this case in front of the U.S. Supreme Court, argued today, has implications in beginning to peel back some of that special privilege that union officials have to kind of exercise these unique, and I'll use the word unique with finger quotes, privileges that they've gotten under the law to, in this case, destroy property and be completely vindicated of it by a legal system that protects union officials' privilege and militates against business owners' property rights.
And that's what I want to ask you about these, as you said, outrageous implications. So what are some of those of what these union bosses are demanding here?
Yeah, what's happening here is that the union officials say they're exempt from any prosecution, whether it be criminal or whether it be civil, because this is protected activity under the National Labor Relations Act. Back in 1959, in a case called Garmin, San Diego versus Garmin, the Supreme Court gave the NLRB vast and broad jurisdiction over this type of activity. And basically what they said is if the NLRB decides that this is not vandalism or this is incidental as opposed to intentional, that they have jurisdiction over it. And basically the company is barred from filing a tort claim, if you will, in Washington State Court. That's what it was about. They filed a tort claim saying, hey, there was property damage here. We want reimbursement. The district court basically said, no, you don't get it because it's protected activity. Appeals court said, yes, you do get it. Supreme Court of Washington State says dismiss it. And now we're in front of the U.S. Supreme Court. And we filed a brief in the case talking about this expansion, that this case would actually protect and expand union privileges to basically, as Justice Kagan said today in the argument, your argument, to give union officials maximum pressure at the most important time. So delivering cement trucks with full loads of cement back to the yard with no intention of ever delivering it, with intention to go get it, drive it out, then drive it back and leave it there, and then ending up in property damage, she says is allowing them to use maximum pressure at the right time to get what they asked for at the bargain table. It's really kind of an amazing privilege.
It really is. And I mean, speaking of this, so property damage, basically, what are some of these other exemptions or loopholes, privileges, whatever you want to call it, that unions currently seem to enjoy?
Yeah, Kara, and your viewers are going to make comments about this, but in 1973, the Supreme Court ruled in a case called Enmons, E-N-M-O-N-S. They ruled that union officials were exempt from prosecution under federal law, under anti-extortion laws and other laws that you and I would be covered with if we got together and tried to extort property from someone, saying that their incidents of union violence, if they were used to achieve, quote, a legitimate union objective, were exempt from prosecution under the law. So that's one kind of a get out of jail free card for union union officials. In fact, when Pasma Lasma, the Top Chef host, went to Boston and tried to film a show there, the Teamsters Union was really upset because they were non-union labor, and so they went out and shut the whole thing down, and they made some comments that I can't say on TV about what they were going to do to Pasma or whatever her name is if she didn't comply. And basically the court said, you know what, no problem here. The unions had a legitimate objective to try to get this work, and so Edmunds would protect them from any prosecution for these acts of intimidation and violence that, again, you and I, Kara, would be prosecuted against if we exercise them in ordinary affairs with other people.
And so last 30 seconds here, as you're mentioning, your foundation has filed an amicus brief in this case as it goes before the Supreme Court. We won't, of course, hear a ruling on that for a little while, but how would you like to see it? What would you like to see in the final decision if you were able to maybe, pen the majority decision?
Well, we'd like to see that the court would recognize that these rights aren't unique for union officials because they have this, this ability collectivism, that any type of arrangement, an agency relationship between, two people should have the elements of a contract. This doesn't. And when you use vandalism, whether intentionally or as a result of your actions, I mean, someone has to pay for that. The company can't be out there hung out to dry when this action was coordinated and then this damage was inflicted on them by this labor dispute.
Well, Mark, I really appreciate it. Thanks for joining us tonight.
All right, Kara, thanks for the opportunity.